Hi, everyone, and welcome. I am Emily Tolliver with the Kentucky Resources Council, and we are so glad that you're joining us today for our KELI session. The Kentucky Leadership, Kentucky Environmental Leadership Institute is designed to give local leaders and engaged residents the tools they need to navigate environmental decision making in their communities. Today's topic is on solar siting, how and where large-scale solar projects get built, and what role local planning plays in shaping those decisions. It's a timely, complex issue, and we're honored to be joined by Tom FitzGerald to help us unpack it. Fitz is the former director and now of counsel for KRC and has spent decades working on land use, energy, and environmental policy in Kentucky. He is a longtime champion for fair, community-centered environmental policy. We will have about 15 minutes of Q&A at the end, so feel free to drop your questions in the chat as we go. Fitz, we're so glad to have you here today. So with that, I will let you take it away.
All right, well, thanks. And folks, if there are questions that come up also during the presentation that you want clarification on, please don't be shy just to jump in, okay? What I hope to do is to kind of set the table and raise some of the issues and then do some question and answer. But let me start by explaining what KRC's role is in this process. As many of you know, KRC has been around since 1984 as an environmental legal aid project. We do air, waste, water, mining, utility policy, energy regulatory policy issues, and we don't accept government grants. We don't accept corporate money, and we don't charge for what we do. So, I tell people, I say, you get what you pay for. But we are here as a resource, specifically on the issue of siting of solar facilities. As is the case with many issues over the years, we start receiving phone calls, people asking questions, people raising concerns, and we realized back in 2020 that there was a need to address the issue of siting of utility scale solar facilities. And so we adopted and we proposed, and then we've gone through a number of iterations of ordinances that can be adopted at the local level by cities, by counties, or by, if you have a multi-county planning unit, by multi-county entities to address the siting of solar facilities of various scales. And so today we're really going to talk not about rooftop solar and small ground-mounted systems that might be backyard systems or community solar systems, but we're going to talk about utility scale solar systems. And let me start by giving a little bit of history on this. Back in 2002, the General Assembly realized that there was a need to address the siting of electric generation facilities, so-called what we now call merchant facilities. Merchant facilities under Kentucky law are defined as a facility that is not a public utility and is not a what's called a qualifying facility, which is a facility regulated under the Public Utility Policy Act of 1978, PURPA, that is generating electricity at the wholesale level and selling it to the local utility. Merchant plants are non-utility wholesale power generating plants that are over 10 megawatts in their capacity. So what was happening back in 2000, around the turn of the 2000, 2001, is there were a number of so-called merchant plants that were looking at Kentucky to site not solar facilities. At the time, it was either so-called clean coal plants or it was a gas plants. This is the era before their meltdown of Enron and other companies like that, that were not utilities, but were proposing to generate electricity and then to wheel it into the grid and sell it at wholesale to a utility who would then distribute it to their customers. Historically, utilities had their own geographic service area, They had a monopoly on serving customers there, and they would generate electricity and they would have the reserves necessary to meet their local load for their customers. And increasingly in the 1980s, 90s, and 2000s, we saw a regionalization of electricity where you had the grid more interconnected, one utility using their reserves to assist another utility, and a wholesale market developing on the sale of electricity from generators to utilities, from one utility at wholesale to another utility for distribution to customers. And Kentucky was no stranger to that. We started to see proposed facilities that were going to site at the intersection of gas pipelines and transmission lines. And so Oldham County saw one. Up in Perry County in eastern Kentucky, we had a company that was going to take waste coal and combust it to generate electricity. Peabody, which is a coal company, proposed a mouth of the mine, so-called advanced coal or clean coal plant, the Thoroughbred Energy plant down in Muhlenberg County. And the legislature realized we didn't have a siting process to address these types of facilities. So they created the Electric Generation and Transmission Siting Board, and they created a siting board process for any of these merchant plants that were over a certain size in terms of their generation of electricity, 10 megawatts being the cutoff. Now, so you have the siting board. The siting board is there, whether a county does anything, whether they have a local siting ordinance, whether they decide not to. But under the siting board process, there is a requirement that an applicant for a so-called merchant plant apply for a construction certificate. And in that application, they have to include background information. Fortunately, I was honored to be part of the drafting of that bill back in 2002. And so you've got certain basics that have to be submitted. You have a site assessment that looks at the impact on other properties, looks at the impact on the natural environment, requires mitigation measures be developed. You've got a siting board, which is made of the three members of the Public Service Commission, and additionally, the county judge executive and one citizen from the county, or if there is planning and zoning locally, it's the chair of the Planning and Zoning Commission. And you have a process of notification of the public participation, and then a decision by the siting board on whether or not to approve the construction certificate and whatever mitigating conditions are required to be put in there. So that process was put in place. And in 2002, there were 5 or 6 different plants. There was one in Estill County, one in Muhlenberg County, one in Perry County. And then after that flurry of activity, and I don't believe that, if to my knowledge, any of those plants were actually constructed, right? Because there was a change in the economics of some of them were questionable to begin with, but there were construction certificates that were issued. Some of those certificates were challenged, and none of the facilities were actually constructed, to my knowledge. But after that point in time, there were several years in which there was little to no activity. There was, I think, one application for a transmission line that was a wholesale transmission line. There were a couple of other applications in 2005, 2009, all the way up until 2020, when suddenly, and the first inkling I had of this is when the then chair of the Public Service Commission said, Fitz, we need some money put into the budget by the House or Senate, because we've got this flurry of new applications that we anticipate are going to be coming within the next year. Well, sure enough, starting in 2020 and all the way up through 2025, we have had over 50 applications. I think all of them have been solar, to my knowledge, for merchant power plants that want to construct in Kentucky. And you're wondering, why is that? Why the sudden surge in interest? Well, you have to look at the fact that Kentucky sits in 2 interstate transmission organizations. We are connected to MISO, the Midwest Independent Service Organization, and we also have PJM, Pennsylvania, Jersey, and Maryland, which is the interstate independent transmission organizations that manage the grid connections among the various states. Some utilities are members, some utilities are connected but are not members, but utilize these interstate transmission organizations to meet some of their capacity or meet some of their electricity needs. But what has happened is with the development of renewable mandates from other states, we don't have one in Kentucky, the siting of these merchant facilities that are generating renewable energy and renewable energy credits that can be utilized by other states' utilities in order to meet their state goals for decarbonization or for a certain amount of renewable generation. We have become a very kind of hot item, partially because of the access to the transmission grid, partially because of the relative cost and availability of land. And so we've got a number of these facilities. Now, how many of those will actually be built depends on the market, depends on the investors, depends on the interconnection, because there is a backlog going back several years now of electricity that wants to access the grid and are in the queue to access the grid, but there is a significant backlog in their ability to do so. And so it is, like David Brown Kinloch, who's one of the investors and owners of the Kentucky Hydro Partners, getting involved in solar generation at the utility scale level is not for the faint of heart, because the connection process is a very daunting process because of the delays. We've morphed nationally from utilities that are centrally located, distributing electricity to the transmission system, the distribution system, the local consumption, to a significant use of distributed generation, and to a hodgepodge of some states that are regulated in terms of their utility environment and other states that have unbundled and deregulated so that there is no overarching utility mandate to serve, but instead the utility customers are choosing their suppliers, and the suppliers are selling into the market rather than at controlled rates of return and controlled rates for the customers. So it's a complex interstate picture, but the reality is that Kentucky has become very attractive to solar developers who are seeking to get the construction certificates and get the local permits, and either to construct themselves or more likely to sell those assets to someone else who will actually invest in the construction of facilities to sell electricity at the wholesale. So let me set a little bit more of the table. Because Kentucky started to see this surge in interest, we decided at KRC that we needed to try to develop some tools for local governments, because we are big believers that the unique needs of each county are best served by the county officials and the city officials utilizing the tools available to them under Chapter 100, which is planning and zoning. But even in the absence of planning and zoning, which we know in some communities, and with good historic reason in some cases, tends to trigger some adverse reactions. No one likes to be told what to do with their property. In my experience, right up until the point that the junkyard moves next door, and then they're like, wait a second, that's not an appropriate land use. And unfortunately, when you don't use planning and zoning, you deprive your community of one potential tool to assure the compatibility of one use relative to another, and to protect the sunk investment of homeowners and of other property owners in the land and in the community that they have developed. So I'm a big believer that properly constructed planning and zoning can be a very valuable tool for communities in terms of protecting quality of life and in terms of assuring the compatibility of uses. But I fully understand that in some communities, it's just not in the cards, at least in the immediate future. So what we have done is to draft ordinances that can be utilized both by counties that have planning and zoning and those that rely on more general authority under KRS 67083, which is the so-called home rule statute that provides the specific additional authorities of fiscal courts at the county level to regulate commerce, to regulate nuisances, to protect and conserve the environment. So we rely on those authorities in those counties. Let me hit one other issue before we talk about some of the potential for local communities to be involved in a positive way in managing the integration of solar facilities into the community. And that is what happens if the utility is the one proposing a solar facility? Well, under Chapter 100, which is planning and zoning, local planning commissions don't have the authority to control utility power plant siting, and that includes solar facilities. Just as it includes gas facilities, it includes oil facilities, it includes any type of utility owned facility. They are considered exempt, whether they're regulated by the Federal Energy Regulatory Commission, which regulates hydro and regulates interstate transmission of electricity and interstate sale of electricity, or they're regulated by the State Public Service Commission. Those are not regulated by planning and zoning, right? But there is an obligation that a utility has to, when requested, to brief planning and zoning commissions on what their plans are for their facilities, for new facilities, for changes of facilities, but it's on request. So one of the things we've suggested in these local ordinances is that you put in a standing request to all utilities. If they have any plans for developing new facilities, they have to come to brief the local planning commission, which gives the public an opportunity to hear about those plans. And the second point where the public can interact with the utilities on these issues is during the regulatory review process. Now, if I am using any public federal money, which in many cases is going to be the case for any of the co-ops, because as you will recall, the co-ops were created by the Rural Electrification Act because the investor-owned utilities and the municipal utilities, left to their own devices, did not want to serve the rural areas. So we had a major federal investment under the Rural Electrification Act to extend service, and we have a cooperative model, a nonprofit cooperative model to manage a lot of those rural utilities. Many cases, they rely on loans or grants from the Rural Utility Service. And so with that federal trigger comes compliance obligations under the National Environmental Policy Act, which is the source of this so-called EIS, or environmental impact statements. In many cases, what you're going to see instead is a stepped down environmental assessment. But during that process, some of you, if you're co-op customers, have come in contact with that, where there's a new transmission line being constructed, or a new gas plant being constructed, or maybe a new ash landfill to deal with the coal combustion ash. You get a notice that there is an environmental assessment being developed. So during that process, there is public input on what should be studied, on what the impacts are, on whether the project should go forward or not. The environmental impact statement or the environmental assessment doesn't control whether that process will go forward, but it does give an opportunity to look at the environmental impacts, including community impacts. So you've got for co-ops, if there is a solar plant that's being proposed, you've got that process. You also have the process for any utility regulated by the Public Service Commission has to get what's called a CPCN, Certificate of Public Convenience and Necessity. So they will have to go to the Public Service Commission and ask for that certificate and demonstrate that there's a necessity for this facility. But one of the things that we're required to do is to do a site compatibility assessment. So that's a second point where you have the ability for any public utility to comment on the suitability of that site. And to bring it full circle, the site assessment that a utility has to do is the same standards by and large as a merchant plant, because the utility site assessment refers back to the standards for a site assessment for a merchant plant. So by commenting or by intervening in the certificate of need proceeding in front of the Public Service Commission, communities and community groups can have a voice in the Public Service Commission determination of whether the site is suitable for a utility solar plant. So now we'll switch gears a little bit and talk about merchant plants. The siting board process, as I mentioned, is going to go on whether local communities engage by doing a home rule statute or by modifying their planning and zoning to address solar siting. But there are a couple of areas where state law specifically contemplates that local communities will be active and, in fact, makes their local determinations primary over the state siting board. And that's why I think it's really important for local communities to become engaged. One of them is in setbacks, right? Now, anybody that's dealt with planning and zoning knows that historically, the way that we've addressed potentially incompatible land uses is by spacing them out, right? It's by creating a setback between use A and use B. We've learned over the years, particularly in some of the cities, that since we're not manufacturing any more land, simply using space is a kind of an inefficient way to address incompatible uses, and that there are ways to make uses more integrated with each other by using good siting, good landscaping, good thoughtful kind of siting analysis that fully respects the correlative rights of neighbors not to have their potential to develop their property or to not develop their property be respected. Right? And that's what we're really looking at. We're looking at how do you allow an individual within reason to develop their land in a productive way, however they define productive, and protect their correlative rights against somebody else who wants to do a use that is maybe more intensive or different than what they are using the property for. And a lot of the battles that we've had over the years, a lot of so-called nuisance law arises in that interaction between industrial use and residential use, or commercial use and residential use. And so we're trying to set the standards so that we create a rational process that respects those uses to the extent possible, and which tends to and tries to incorporate change, which nobody likes. None of us like change. It's in our nature not to want to have our lives disrupted by something new that we don't control, right? That's natural. That's normal. And so how to address that in a way that says certain situations, it's just not going to be compatible. Other cases, it could be compatible, but these are the considerations that you need to think about. And so, when we do planning and zoning, or when we do a non-planning and zoning, a permitting process like we're proposing, what we're doing is trying to put in place the rules of the road that allow people to know what are the standards we're going to be using to determine whether this is okay, what are the areas that are off limits, and how do we deal with everything in between. So the three areas that the state really anticipates the local governments are going to be active are in the setbacks issue, in the bonding, right? I say, when I'm doing a facility that's going to last 25 or 30 years, well, I don't have to worry about it because I won't be here. But those of you who will be here, what you're trying to do is assure when you have a facility that is going to have a fairly lengthy life, right? 25, 30 years is what you're looking at for a solar facility before it is repowered, before you have to replace the component parts. And when you're looking at something that has that kind of a tail to it, you want to be sure. It's kind of like, President Reagan said, trust but verify, right? You want to assure that there's some sort of a performance mechanism in place, a bond that will assure that if you or whoever you sell this plant to defaults on their obligation to clean up the site and decommission it, remove the component parts, remove the junk, remove the fixtures that have been put in place to support this use, so we don't end up with a solar version of a big box that is there and is empty and is a blight on the landscape. You want to make sure that there's a bond in place, whether it be a cash bond, whether it be certificates of deposit, whether it be a surety bond, some sort of insurance so that if you default in your promises as a permit holder, as a certificate holder, that their money is there so a third party can be hired to fix the site up so it doesn't become a burden on the landowner and indirectly a burden on adjoining landowners. All right, so that's what a bond is all about. And that's why both at state law and in the local ordinances, you want to adjust the bond periodically to assure that it is staying current with the rate of inflation, with the cost of the consumer price index for construction, not for retail. Because the consumer price retail is what it costs to buy a certain basket of goods at the store. That's not going to have any bearing on what it's going to cost to deploy equipment in order to remove foundations and interconnections and those things. Well, the third area is in what happens at the end of the process. What has to be done to so-called decommission the facility? And there are a couple of key things that local communities can do to better protect the lessors, the landowners who are leasing their property, than state law provides. And we'll talk about those in a second. So, for counties with or without planning and zoning, what are some of the key issues? Well, first issue, I think, is when does construction begin? Right? Now, state law determines that construction begins when you're actually putting in place the superstructure for a solar system. But anybody who's dealt with land use conversion knows that construction impacts can occur much earlier. Right? Cutting timber, removing the standing trees, removing the ground cover, all of those things. You can have significant erosion issues. You can have significant loss of tree canopy issues. And so my suggestion has been, as part of the ordinance, is that construction should be defined as any disturbance of the ground surface that is intended to support this particular use, so that you are backing up the process of when construction begins, so that you would have to come in and apply for local approval. The standards that you put in place, state law requires that there be mitigation, but it doesn't generally talk about setting standards for things like, it requires an analysis of the offsite impacts. And if you look at the siting board statutes and look at the cases that have been approved by the siting board, I think they do a pretty good job of trying to mitigate offsite impacts. But when you have the opportunity at the local level to really tailor those standards to local needs, I think it's foolish not to do that, right? And so standards for things like tree protection, tree preservation, the height, the lighting, noise, how you deal with historic preservation districts, how you deal with visual buffering, what sort of setbacks you require. And in terms of setbacks, I'm a big fan of doing setbacks when you have residential or other properties, setting them back not only from existing structures, but setting them back from the property line. Because if I set a setback from a property line, then I am fully protecting the ability to utilize the adjoining property. If I set a setback only from an existing home, then I've essentially downzoned the rest of that adjoining property. Because if I make a determination that a certain distance is necessary to fully protect a use, and I only use the existing uses, then I'm really limiting what I can do with the adjoining property. So I believe setbacks from existing structures is important, but it's also important to do setbacks from the property line in order to protect future uses. Unless that landowner next door agrees to waive a setback, right? Because we're not trying to tell the adjoining neighbor what to do with their property. We're trying to protect their ability to utilize their property. Now, one of the things that I've seen that I think can work well is that you specify for this type of land use whether you can waive the setback and whether you can reduce the setback, and if so, what you require for a reduction, right? So these merchant plants are going to have a fencing because they're required to have fencing, but they're not required by any federal or state law to necessarily have visual buffers. So additional buffering, additional vegetative buffering, those sorts of things can be required at the local level in order to not only address potential noise, but to address visual impacts, to address any lighting. And one of the big issues, and KRC does not come down on this issue one way or another because it's not our job to do this, is how you deal with utility scale solar and agriculture, right? Unfortunately, in our Commonwealth, all too often, we view agricultural land as throwaway land. And when you look at some more urbanized communities and they look at agricultural land, somebody who's in the development sphere says, well, that's vacant land, rather than that is land that is potentially useful for agricultural purposes. And we tend to, because of our somewhat arrogant view, in Louisville in particular, we tend to name new developments after the most prominent natural resource we've obliterated, right? So we have Fox's Run, and when we have the only like one oak left remaining, we call it Thousand Oaks. So it's important, I think, to recognize that we're not manufacturing any new land, and that agricultural productivity and agricultural land is important, and that conversion of agricultural land for solar is a very small piece of a much larger concern about the helter-skelter conversion of agricultural land. But certainly we shouldn't be contributing to a problem. And so what we've suggested is that there are, depending on the amount of agricultural land, depending on the type of land that is there, the uses that agricultural land is suitable for, because not every land is suitable or appropriate for row cropping, or some may be for silviculture, some may be for habitat. Whatever the landowner's goals are, and whatever the community's goals are in terms of siting future land uses, that should be reflected in your solar ordinance, so that you are sending a clear message to solar developers that you want to protect prime farmland, highly productive farmland, highly erodible farmland, whatever it is that the goals are of the community, all farmland for that matter, that you are requiring that any applicant, that certain state, you can set certain performance standards in terms of soil compaction, in terms of siting of roads, in excuse me, of siting of facilities in terms of integrating solar with other agricultural uses. There are a number of ways that you can incorporate solar energy systems into communities that to address agricultural lands. We tend to believe at KRC that it's only where the landowner lessor is fully aware of the costs and benefits associated with the conversion of agricultural lands, where the siting does not cause offsite adverse impacts, where the enforceable measures are adopted to minimize and mitigate unavoidable or impacts on agricultural lands, where the lands, there's not permanent damage to those lands, where there's not a risk to the future utilization of those lands. So there's design mechanisms, there's siting mechanisms, there are prohibitory mechanisms, a combination of which are available to address the unique needs of each community, as well as respecting the right of the individual landowner to to utilize or to convert their property. That's always for any agricultural land, it's always a balancing act between protecting the integrity of the agricultural lands and recognizing that those lands are in private ownership. But it's our goal at KRC to provide local communities with those tools and to provide the local landowners and adjoining landowners with as many protections as we can so that they can make a decision on how and under what circumstances this particular land use occurs on agricultural lands. Now, part of that, and the last thing I really want to talk about are two related issues. And one of them is, what should come first? Should a developer seeking a construction certificate for a merchant plant in Kentucky be required to come to local government first or after they've got the state certificate? Now, you can make an argument that you don't want to, waste anybody's time at the local level until they've gone to the state level. But I think if you look at, and there's nothing in state law that says thou shalt go to local government first, or thou shalt come to us first. But I think it makes the most sense. At the local level, if a community is going to engage in adoption of a local siting ordinance or a local permitting ordinance, either in the zoning and planning or otherwise, that the community require the applicant to come there first, right? And that is because when you look at the state siting board, it defaults in the setback provision and in the decommissioning and in the bonding to local government. So if local government is spoken first about what it expects, I think that gives the siting board better guidance in terms of what can and cannot be waived. Because if the local government says this is a setback and this is the process, if you want to vary that setback, you got to come to us as a county or a city or of the fiscal court or the planning commission. If it's a county with or without planning and zoning, you got to come to us and we will determine what the setback is. Then that gives the state the guidance because the siting board will not vary from what the county has determined is necessary. Similarly, for decommissioning, if you rely solely on the state decommissioning process, then the solar company gets to leave in the ground when they're done at 3 feet of depth and below any of the infrastructure that was created, the concrete that was poured, the conduit that was laid to run the wires to convert the solar electricity to transmit it to the inverter and to the substation or whatever it has been constructed in order to get it onto the grid, and the interconnection facilities that have been developed in order to interconnect to the grid. Right? Those get to be left behind unless the landowner specifically requests that they be removed. In many cases, the landowner doesn't know that the burden is on them. And what we have suggested is that because the legislature has said counties, you have primacy on these issues, is that the rules should be flipped. Everything should be removed in order to protect the future utilization of that land, unless the landowner specifically waives it and says, it's fine leaving that conduit in place. It's fine leaving the concrete in place. It's fine leaving the interconnection in place. Otherwise, we believe in order to fully protect the utilization of the land, all of that should be removed. And that should be the default at the county level. Now, the big issue, and this is the last one that actually, I'm sorry, I lied to you. Two issues that are related. One is, how do you regulate at the local level if you're a county with planning and zoning? Do you require rezoning for solar uses? Do you make them industrial uses? Do you create a new land use category that says industrial energy or light, medium industrial? These are industrial uses, but they are not intensive industrial uses the way that manufacturing of a chemical might be, or other types of manufacturing. They are, do you regulate by requiring by putting it in a zoning district and requiring that the zoning support it? Or do you utilize the conditional use process or an overlay district process in order to address the uses and to allow them in other districts with certain conditions? We have suggested, and there's arguments to be made in both ways. And again, this is not, KRC is not going to say to any community, you ought to do it this way, you ought to do it that way. We tend to think at KRC that using a conditional use process allows more flexibility than rezoning, and at the same time is more protective of the use of other lands than a rezoning. Now, some communities have decided we're going to allow this only in industrial districts, and that is fine if you've decided as a community that you want to potentially utilize that property for other industrial uses. But in many cases that I've seen, communities in rural areas are more accepting of the idea that you may have a solar facility, provided that that land remains agricultural, that that facility exists under a conditional use permit that limits its growth, that limits its nature, that limits its duration, and requires that it be completely removed, and doesn't open the door for another industrial use to occur in an agricultural area. Because after the construction phase, these facilities tend to be pretty benign in terms of offsite impacts. There is some noise that's associated, but that is less so and is than other types of land uses, and it can be mitigated and managed. I'm not trying to minimize it, but it is in the scale of things a very manageable offsite impact that can be completely mitigated. So we tend to think that a conditional use permit is more useful because you can craft the conditions to meet the specific property, the specific neighbors, the specific concerns that one land might have that another land wouldn't, because of the virtue of its relative geography, geology, hydrology. And so that you have an ability to craft a more specific solution that provides for that use, but doesn't open the door or shut the door for other facilities that may come down the road, right? And that's where we come down, but I fully understand if communities wanted to go about it with a zoning limitation. And you can also combine them. You can say, we made a determination that residential zones are just not appropriate for generally speaking, for utility scale solar. And we are going to allow it in commercial areas and industrial areas, or we're going to allow it only in industrial areas. Again, it is the local community's decision after really doing some public involvement and public participation. And that's the last issue, because I'm running a little bit beyond where we wanted to go for question and answer. And that is, I'm going to save you all a bunch of money right now, okay? Because there's a guy years ago I ran into who he's probably retired now. But he used to teach this seminar, and it cost a lot of money, I think, to go to the seminar. But the seminar was about the relationship of risk and outrage. And basically, after an hour's worth of slides, the bottom line was the more the public feels excluded from the process, the more the heightened the more heightened the perception of risk is going to be. And that what drives that is a correlative sense of outrage, right? No one likes to be the last person asked their opinion. No one likes to find out that the local government officials have been in the process of negotiating for 9 months or a year or 2 years on a particular project. I can tell you from very recent experience, when the residents of one of the Louisville neighborhoods, actually it was 4 Louisville neighborhoods, found out that the mayor had signed a letter of intent to build a Billie Jean King Center sized tennis facility in the middle of a neighborhood park. Um, and 1,000 people showed up for a community meeting, that people were a little pissed off that they hadn't been asked their opinion first, right? So risk and outrage go hand in hand. And my experience after 40 some odd years as an attorney working with citizens, but even longer than that as an advocate, is don't ever treat the citizenry as an afterthought, because bad things happen when you do. Projects are much more difficult. Projects end up in litigation. They are everything that a developer doesn't want. But the tendency has always been the less the public knows, the better. The later the public's involved, the better. And I can tell you that just isn't the case, because my experience has been not that everybody always agrees and every project always goes forward, but my experience, whether it be Scott Paper when they cited in Owensboro, or it be Louisville, University of Louisville when they wanted to build a new hazardous waste storage facility on the Belknap campus, or it be any number of other processes, if you engage the public early and you engage the public honestly, and it's, some local governments unfortunately believe that public engagement means setting up a meeting and speaking at people in slow declarative sentences of short length. That's not public engagement, right? And there is an opportunity under the siting board statute, on request, if a developer is in the process of attempting to acquire real estate for the purpose of constructing any merchant plant, if requested by local government, they have to hold a hearing, a public meeting. The problem is local governments are not going to find out about this necessarily until somebody has been in the community going around and acquiring easements or other property rights, potentially for some time. So our suggestion, and this is, if there's no other reason that a local government gets involved in this, is you can flip that script and say any time a party is in the process of acquiring real estate interests for the purpose of constructing a merchant power plant, you should notify fiscal court and or the planning commission and hold a public meeting, right? And let the community know, we would like to be part of the community. This is the facility that we're proposing. This is the area where we'd like to do it. We want your input. Does this work? Does this not work? Under what circumstances would it work? What are your concerns? And is this just a non-starter? Right? And you'll find that the concerns become more focused, that the potential for compromise and compromise not in a way that everybody gives up something that is important to them, but that you you change your design, you increase your focus, you change your location, you change any number of things in order to fully protect the values that you're trying to protect. So it's not compromise in a way that you're giving away something essential. It's compromise in a way that you are adapting a particular project to provide positive benefits and to minimize anything negative. So I'm going to stop there. I have talked plenty long enough, but I want to encourage you, if KRC can be helpful in your community, please do not hesitate to reach out to Emily, to reach out to Ashley, who is my boss, who's the director of KRC, and Emily will tell you how you can do that on our KRC website. But please, if there are questions that come up, that's what we're here for, right? And we've worked with people downhill and downwind and downstream for over 40 years with a goal of providing, helping to provide positive ways to protect the quality of life in communities, to adapt to change, and so we're here, and so please don't be shy to reach out to us. So, Emma, I'm going to turn it back to you if there's questions that folks have.
Absolutely. If you have any questions, feel free to come off of mute and ask away, or feel free to drop your question in the chat. We have a few minutes for questions.
Sam.
Yeah. Hi.
What's up?
Thank you, Tom. I really appreciate that. That was a good presentation, and it's a very important issue. I've been involved in a couple of hearings on this subject, and I want to say that I think it's important to promote utility scale solar, because I don't think there's any way we can achieve any of our renewable energy goals without it. We're looking in Louisville, we have a goal of 2040 for 100% renewable energy. Worldwide, we have a goal of 2050. And if you look at that, that's 25 years from now, which is the same length of time we're talking about for a decommissioning bond for some of these solar installations, utility scale solar installations. And that's important because I don't think that utility scale solar is going to be around permanently. I think of it as an intermediate step, a step 25, 30 years, whatever it takes, in order to accelerate the transition to renewable energy. But because of the decommissioning bonds that you talked about, that's really important. What that means is that even if you're using agricultural land, it's going to be available for agriculture again during the decommission, or after the life of the project has finished and the decommissioning sets in. And it's not like a subdivision. It's not like a strip mall. It's not like an industrial park, because those are permanent development. You can't get that back to agricultural land or to any other use. But because of the decommissioning bond, we can use utility scale solar for the intermediate period, at which point, after 2040, 2050, there are going to be other forms of technology. We're going to have more rooftop solar, for one thing. We're going to have geothermal. We're going to have other forms of renewable energy at that point, and probably can no longer rely on using a lot of land for solar installations. So I think it's important to promote utility scale solar as an intermediate range solution, as an acceleration of the transition, because we have to do that before 2040 or before 2050. So let's use that land for a temporary purpose and then let that decommissioning set in. So I thank you very much for covering those things in this presentation.
Thank you, Sam. Yeah, it is for those who, are want to read more about where things are going.